Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Somebody asked that I cover the Johnson versus City of Grants Pass case.
We'll hear argument first this morning in Case 23-175, City of Grants Pass versus Johnson. Ms. Evangelos.
Mr. Chief Justice, and may it please the Court, like cities nationwide, Grants Pass relies on camping laws to protect its public spaces. These generally applicable laws prohibit specific conduct and are essential to public health and safety. The Ninth Circuit tied cities' hands by constitutionalizing the policy debate over how to address growing encampments. It's holding that the Eighth Amendment bars Grants Pass from enforcing its camping laws is wrong for three reasons. First, the Cruel and Unusual Punishments Clause governs which punishments are permitted, not what conduct can be prohibited. Second, no precedent supports the Ninth Circuit's rule. Respondents in the United States abandon its reliance on Powell. Instead, they misread Robinson to bar any punishment for involuntary conduct that's linked to a status. But Robinson held only that states cannot outlaw the status of drug addiction. It made clear that they can prohibit conduct like drug use. This Court should not rewrite Robinson 6 decades later. Third, the Ninth Circuit's approach has proven unworkable. The Eighth Amendment does not tell courts who is involuntarily homeless, what shelter is adequate, or what time, place, and manner regulations are allowed. But in 35 suits and counting, federal courts are now deciding everything from the exact size of campsites in San Rafael to the adequacy of empty beds at specific shelters, like the Gospel Rescue Mission in Grants Pass. And cities are struggling to apply arbitrary, shifting standards in the field. This Court should reverse and end the Ninth Circuit's failed experiment, which has fueled the spread of encampments while harming those it purports to protect. I welcome the Court's questions.
Before we go too much further, let me explain the Robinson problem. Robinson is a 1962 case from California, and it made it a misdemeanor punishable by imprisonment to be a drug addict. And the Ninth Circuit and the Supreme Court both agreed that the status of being a drug addict was not something that could be criminalized, that you could criminalize conduct, but you couldn't criminalize someone's status. And that's been the law since 1962. And that is the case that is causing the plaintiffs here the big problem with the court.
Do you consider these civil or criminal penalties?
They are both, Justice Thomas. There is criminal trespass and civil.
Is that involved in this case?
Yes, it is.
To what extent? I mean, has any of the petitioners, any of the parties here, been subject to criminal trespass?
Well, they are at issue in the case. The district court enjoined them, and yes, they do apply here. They are for recidivist offenses.
But which party has been held accountable for criminal trespass?
So here, none of the individuals who are currently in the case.
So what's involved in this case?
For Logan and Johnson, the civil penalty.
And so what, is it the anti-camping or what is it?
Yes, it is.
Okay, so that's civil or is it criminal?
The camping ordinance is civil, and then for repeat offenders, it's punishable by criminal trespass.
But we're not talking about repeat offenders right now, right?
That's correct.
So then, have we ever applied the Eighth Amendment to civil penalties?
Not the Cruel and Unusual Punishments Clause, no.
Counsel, what will the city do if you don't prevail here?
The city's hands will be tied. It will be forced to surrender its public spaces as it has been. Unfortunately, beds are going unused at the Gospel Rescue Mission. People are not getting the help that they need. The city is under an injunction here, and it's unable to rely on these basic ordinances. And the Ninth Circuit's decisions give cities like Grants Pass no guidance about how they can navigate this very challenging area. The Ninth Circuit has effectively imposed a municipal code under the Ninth Circuit's Martin rule to regulate what the city can do in its public spaces.
Now, Justice Thomas seems to be concerned by the fact that none of these people have actually faced a criminal penalty, as he should be. And Justice Roberts seems to be looking into what's going to happen to the city if it can't enforce its ordinances. Both of those things are important. Coming up, we're going to hear from Justice Sotomayor and Kagan and Jackson on the issues that are raised in the petitioner's briefs. And they're going to be focusing on whether or not homelessness is a status and whether that's actually the effect of this particular ordinance, whether it actually criminalizes the status of being homeless.
Counsel, can I just stop you a moment? The gospel unused beds, they're less than 100, right?
That's correct.
And there's thousands of homeless.
There are, I believe, as many as 600 in Grants Pass, according to the district court.
But there's still only less than 100 beds.
That is right.
Now, can I stop you a moment? You are not asking us to overturn Robinson, correct?
We think Robinson was wrongly decided and should not be extended, but we don't think that the court needs to overrule it here because
assuming it's there, it prohibits you criminalizing homelessness, right? So what you do is say only homeless people who sleep outdoors will be arrested. That's the testimony of your chief of police, two or three officers, which is if you read the crime, it's only stopping you from sleeping in public for the purpose of maintaining a temporary place to live. And the police officers testified that means that if a stargazer wants to take a blanket or a sleeping bag out at night to watch the stars and falls asleep, you don't arrest them. You don't arrest babies who have blankets over them. You don't arrest people who are sleeping on the beach, as I tend to do if I've been there a while. You only arrest people who don't have a second home. Is that correct?
Judge Sotomayor here is trying very hard to make it seem as if they are criminalizing a status instead of conduct. Now, over and over and over again, this is the argument that we have. And this is how the petitioner here would like to see the problem resolved. Is homelessness a status or is it conduct? Well, what does the statute say? Does the statute prohibit sleeping outside with a blanket? Yes. Does it prohibit being homeless? Well, the answer to that is no. So back over here on the left side, does it prohibit camping outside or sleeping outside with a blanket? Yes. Is that conduct? Yes. And does that violate the Eighth Amendment? No, that's not a conduct. A conduct is not a reason to impose the Eighth Amendment. You only impose the Eighth Amendment under that Robinson test if indeed there is a criminalization of someone's status. So someone can be sleeping outside and indeed stargazing, and even though the cops testified they might not arrest them, that is within their discretion to do. What they are looking for is trying to find a way to stop people from building homeless encampments, and that's a lot different than somebody sleeping out under the stars or somebody sleeping on the beach in the daytime when they are out at a place where people routinely nap. So again, you can see what Judge Sotomayor here is doing, and essentially she's trying to get them to admit that this is a status issue instead of a conduct issue, and obviously the petitioners don't want to do that.
Can I talk about that, Ms. Kapoor? So taking Robinson as a given, could you criminalize the status of homelessness?
Well, I have a couple points to that.
It could criminalize just homelessness.
So I want to say first a couple of things. So I think that for
that's quite striking.
No, I don't.
That you think that you can criminalize just homelessness.
No, we're not saying that homelessness is a status, but most importantly, I think the Eighth Amendment is the wrong way to focus on this question.
It's really a simple question. Can you criminalize homelessness? And you're suggesting, yes, you could.
No, we do not criminalize homelessness. I'm not saying...
Could you criminalize homelessness? Not tell me what you do, what you don't do. Could you?
So I think there would be due process problems and vagueness problems. I don't think there's an Eighth Amendment problem in the sense of Robinson, because that was a limited decision where the holding was solely about a disease of addiction. The court was very clear about distinguishing between addiction and possession or use. And so...
Now, I shortened that up quite a bit because Judge Kagan kept interrupting her. At no point did she say that she could criminalize homelessness or that she wanted to criminalize homelessness. She kept going back to conduct. And I think that's probably her strongest argument. But Judge Kagan doesn't like that. She wants to get to the issue of a person's status, which truthfully isn't really implicated by the ordinance here. Then Justice Kagan completely goes off the reservation when she talks about whether or not sleeping in public is the same thing as breathing in public, which no rational person even conjures. I can't believe that she went here, but listen to this piece of argument here.
Too. But presumably you would not think that it's okay to criminalize breathing in public.
I would like to point to the federal regulations.
And for a homeless person who has no place to go, sleeping in public is kind of like breathing in public.
And now Justice Jackson is going to pick up on this basic human needs element and carry it forward with her question.
Can you answer why? Why is it not? Justice Kagan has laid out one of the essential problems here, which is that you're making a distinction between status and conduct. Okay, we see that. And you keep saying this is conduct. Can you explain why?
The actus reus element, that's exactly what was missing in Robinson, and that's what we have here. And that's why that law was so unique. It's a very peculiar...
So it seems to me that Robinson actually hurts you and not helps you in the following sense. It seems both cruel and unusual to punish people for acts that constitute basic human needs.
At the end of the day, what you wind up with is Judge Gorsuch and Judge Kavanaugh asking interesting but ultimately unhelpful questions, and then Judge Gorsuch essentially suggesting, look, there is a defense to this. The defense is necessity. When someone can't possibly comply with the law, the defense of necessity comes in. Now, one of the judges says, but Oregon wouldn't allow that in this situation, or perhaps it was the other side, but at the end of the day, there is a good necessity defense, and if the Supreme Court decides that's what ought to be employed instead of a broad sweeping injunction, then again, that's probably a better way to handle this problem than asking the city not to enforce any of its camping ordinances. Essentially, what the city was going for was cleaning out the parks, keeping all of the homeless people out of the parks. Now, again, there's lots of different places people can camp out in the woods in Oregon, and they're certainly free to do that. But when they come and they essentially congregate in the parks, they wind up depriving other people of the use of those parks. You could think of it sort of in a communal way as a property issue, because all citizens have a right to use that park. But if you've got drug-addicted homeless people sitting there shooting up in the park, making a mess of the place, throwing their IV needles out, or their used needles out on the ground, and their booze bottles and all that kind of stuff, and among other things, using it as a complete porta potty, meaning that they're not actually using the porta potty, they're using the ground around them as a porta potty, that creates a public nuisance, and it essentially obviates the recreational utility of a park. I think that's the part of this that the court is not talking about and is missing. And of course, they don't want to demonize these people and tell people that they're all drug addicts, but a large majority of the people who choose to be homeless choose to be homeless because they do not fit in society, and one of the major reasons why they do not fit in society is because they are drug or alcohol addicted, and they simply cannot adjust their behavior to what is expected in a polite society. We'll have to wait and see how the Supreme Court does that. In case you're wondering, I certainly am biased in favor of the city of Grants Pass, and I hope that the Supreme Court makes the right call on this case. If you have any questions, put them in the comments down below. Like, share, subscribe. You can certainly email me at the address above. And then, when you're done, feel free to come on back and join me at the beach again next time, and we'll talk about something else that maybe isn't as depressing as homeless people.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.